Hello and good morning friends, welcome once again to the CEC-UGC live lecture. Dear friends, as you know that we always try to bring for you different subjects, and under these subjects we try to cater for you different topics so that it becomes convenient for you to study the different topics as well as get in-depth knowledge on those topics. Dear friends, in our previous session we discussed on various aspects. Today we are going to talk on the president rule in India. We are going to discuss on what grounds president rule is imposed, as well as what are the provisions for the enforcement of the president rule in India, what happens when the president rule is misused, and what could be done to safeguard the president rule. For this, dear friends, we have again with us in our studios Dr. Rakesh Kumar. Dr. Rakesh Kumar is Assistant Professor in University School of Law and Legal Studies, Guru Gobind Singh IP University. Dear friends, we all know that Dr. Rakesh Kumar visits us frequently, and with the help of the EduCit platform, he gives us a resourceful knowledge so that you could feel that you have ample of knowledge with the help of which you can study your course material as well as you can empower yourself with lots and lots of knowledge. So without wasting any time, I would like to welcome our guest Dr. Rakesh Kumar. Dr. Kumar, welcome to the EduCit lecture.
Thank you, Ritika, and good morning, listeners. On my previous lectures, I have given you some idea about what are the provisions regarding the impositions of emergency under Article 352 of the Constitution, and in that context, I have also explained you as to what are the consequences of the proclamations which may be issued by the President under Article 352 of the Constitution. Apart from this, I have also given you the fair idea about what are the safeguards which has been introduced by the Constitution's 44th Amendment Act to check the possible misuse of power by the President under Article 352 of the Constitution, and what are the repercussions of the impositions of the emergency under Article 352 of the Constitution with respect to the vis-a-vis the fundamental rights. In today's lectures, I am just going to expand on this proclamation aspect by discussing the President rule in India. Because this is the provisions in the constitutions under which the president rule can be imposed in the state government is the crux of the tensions between the center and state relationship, and the repeated use and misuse of the provisions regarding the president rule under Article 356 create tensions between the center state relationship. As all of you know that here the Indian Constitution has provided for the setting of the federal form of the government, and the basic aspect of the federal form of the government is that it has provided for the setting of the two form of the government, one form of the government at the central level and other form of the government at the state levels. And in the federal scheme, here the both form of the government are not subordinate to each others, but they are coordinate to each others. And apart from the strict principles of federalism, we have also somehow evolved the concept of cooperative federalism, where the both from the government are required to work in tandems, they are required to work in cooperation with each others, not in subordinations to each others. But at the same time, we also have the provision in the constitutions where the central government has been given the unrestricted power to interfere in the working of the state government, and they have used the provision of the constitutions to dislodge or dismiss the democratically elected government in the respective state government. And here this can be done only under the provisions of Article 356 of the Constitution. So as far as the Article 356 of the Constitution is concerned, it is create tensions between the working of the center-state relationship, and here because of the constant use or misuse of the provisions by the successive central government, it has created a climate where the various regional party, whether it's a DMK or AIDMK or the National Conference or in the Samajwadi Party or Samata Party, they have lodged their protests against the constant misuse of the power by the president under Article 356 of the constitutions. And in some of the state government or the regional political party has gone to the extent of requesting the central government requesting the central government and parliament to go for the repeal of the provisions like the article 356 of the constitutions. And here because their misapprehension is their apprehension is not misfounded, and there is a solid basis for the lodging this kind of protest. As far the constitution's maker is concerned, here the unity and integrity of the nation was their sole concerns, and that is why they have decided to incorporate the provisions like article 356 of the constitutions. And if you see the constituent assembly debate aspect, then this issue has directly cropped up before the during the constitutional debate, and if some of the member has expressed the apprehension that if this kind of power will be given to the central government, then definitely in that case it will be used by the central government to dislodge the democratically elected government which is being ruled by the opposition's political party or by the political party which are not in power in the central government. So, and if you see the how this provision is being constantly used here, this provision is being used for more than 112 times by the successive central government for the purpose of dislodging the government. And you can simply imagine the magnitude of the this problem is that here this provision was being used for 48 times by the Mrs. Indira Gandhi when she was the Prime Minister of this country. So, here this is the provisions here which has raised a very serious question mark as to whether we need to have the provisions like article 356 at all or not. So, as far the today's lecture is concerned, I have just divided my lecture into three aspects. In the first part, I will try to give you the idea as to what are the constitutional provisions regarding the impositions of president rule under article 356 of the constitutions. In second aspect, I will discuss about what are the grounds on which the president rule can be imposed under article 356 of the constitutions, and in second aspect I will give you the ground pertaining to the ranging from the constitutional breakdown, the political disturbance as well as the physical breakdown. So, these are the grounds which we will take as to how these grounds is being identified and how it could be one of the possible ground for the impositions of president rule by the central government under article 356 of the constitutions. Apart from this, I will also discuss about what are the views which was being expressed by the different commissions or committee appointed by the central government to examine the center-state relationship, and what are the view which was being expressed by the Raj Manar committee which was appointed by the DMK government to inquire about the entire center-state relationship with special reference to article 356 of the constitutions. And the third aspect of my lectures, I will give emphasis on how the provisions in article 356 is being construed by the judiciary, and what are the different guidelines which was being or safeguards which was being suggested by the Supreme Court in SR Bombay judgment to ensure or to check the possible misuse of power by the president under article 356 of the constitutions. And apart from this, if the time will permit, then definitely we will try to give you idea as to how this provision was being used by the successive state government, and in some of the case here the president rule was being imposed on the flimsy ground and with such a urgency that was never being contemplated by the constitution's maker. If you take the view of the Dr. Ambedkar, then he also expressed the view that though we have decided to incorporate these provisions for purpose of maintaining the unity and integrity of the nations, but it will remain a dead letter in the constitutions, and the president before invoking these provisions will issue a constant warning to the respective provincial government as to how they have to mind their conduct as per the provisions of the constitutions. But sadly the hopes of the Dr. Ambedkar is being sadly belied, and this provision was being constantly misused by the respective central government. So, as far as the provisions of article 356 of the constitution is concerned, here first you see the provisions regarding the article 355 of the constitution, and if you see the provisions like the article 355 of the constitutions, then it says the duty of the union to protect the state against the external aggressions and internal disturbance. And what is being prescribed that it imposes a duty on the union to protect every state against the external aggressions and internal disturbance and ensure that the government of every state is being carried out in accordance with the provisions of the Constitution. So, as far the provisions of Article 355 is concerned, here it imposed the two kind of the specific duty on the central government. First, the duty to protect the state from the internal disturbance as well as from external aggressions, and in performance of this duty the center can interfere without the state request. And second is the duty which is being imposed on the central government by Article 355 the Constitution is the duty to see that the government of every state is being carried out in accordance with the provisions of the Constitution. So, in performance of this duty, here the center can interfere with the functioning of the respective state government. But as far the Article 355 is concerned, it is not a source of it is not an independent source of the power for interference with the functioning of the state government. But here the Article 355 is being construed very strictly by the judiciary by saying that it merely provides justifications for the measures to be adopted by the central government in case of the Article 356 as well as Article 357 of the Constitution. So, as far the Article 355 is concerned, it is not an independent source for the impositions of the President rule. It merely provides that what the duty has been imposed, and if the state government is not performing the duty, then what could be the possible consequence. And one of the possible consequence that is being provided is the impositions of President rule under Article 356 of the Constitution. So, as far the rationale for this provision is concerned, I have already said that when the Constitution was being framed, then the Dr. Ambedkar said it will remain a dead letter in the Constitution, and before invoking this provision, the President will give the specific warning to the erring state government or the provincial government to mind their conduct. But as far the provision is concerned, here it is not something which was not there. Here you can find the similar kind of provision which was also in existence in the section 93 of the Government of India Act 1935, from where this provision is being directly drawn. And you can also find the same kind of provisions under the section 119 of the Australian Constitutions as well as the Article 4 of the US Constitution, where the central government or the federal government in the USA has been given the power to interfere with the working of the state government. But as far the rationale for this provision is concerned, this issue was also being examined or emphasized by Justice B.P. Jeevan Reddy in the S.R. Bombay case, where they have stated that the Article 356 of the Constitution is a provisions without a parallel, and no other provisions of the world contains the similar provisions as we have under the Indian constitutions. But why this provision was being incorporated here, he has also provided justifications, and the justification which was given by the Supreme Court in S.R. Bombay case is that the infant democracy required a careful nurturing. Many hiccup was expected in the days to come, and this perhaps explain the need for the provisions like one that we have in Article 356 of the Constitution. So, now I am coming to the substantive aspect of the Article 356 as to what is being provided by this provision. It says that the provision in case of the failure of the constitutional machinery of the state, and it says that if the President on the receipt of the report from the Governor of the state or otherwise is satisfied that situations has arisen in which the government state cannot be carried on in accordance with the provisions of the constitutions, then he may issue a proclamation. So, if you see the provisions like the clause 1 to Article 356, it says that here the President is being empowered to issue the President rule or issue a proclamation under Article 356, but how he will do that? For this purpose, the condition precedent is that either it has to be on the receipt of the report from the Governor of the state or otherwise. So, as far the term otherwise concerns, here it indicates that the suo motu also. It means suppose if the Governor state is working in collisions with the respective state government, and if they are not sending the factual report about the existing law and order situation, the state government, and if the state government to the central government, and if the central government has received the report from some other sources, it may be intelligence sources, it may be report of the media, that, and if on the basis of those reports, the report of the Governor or the report which has been received from the independent source, here the President of the country will be justified to presume that the situations has arisen in which the government state cannot be carried on in accordance with the provision of the constitutions, and what he can do by the proclamation that is being provided by the clause A, B and C of the article 356, and clause A to the article 356 provide that he can assume to himself all or any of the functions of the government or state and all or any of the power vested in or exercisable by the governor or any body or authority in the state other than the legislature of the state. So, here he has been given the power to assume to himself any of the power vested in or exercisable by the governor or any body or authority authorized by him in the state. So, this is the first things which the president can do under article 356 clause A of the constitutions. Then the clause B provide that the president may declare that the power of the legislative state shall be exercised by or under the authority of the parliament. So, once the president had decided to declare the proclamation under article 356 of the constitutions, then that case the legislative power of the state can be taken over by the parliament. And as far the clause C to article 356 is concerned, here the president is being empowered to make such a incidental and consequential provisions as may appears to him the necessary or desirable to giving effect to the objective of the proclamation. So, these are the three consequences which will directly flow from the impositions of the president under article 356 of the constitutions. But if you see the proviso to clause C to the article 356 clause 1 of the constitution, it says that nothing in this clause shall authorize the president to assume to himself any of the power vested in or exercisable by the high court or to the suspend in the whole or in part the operations of the any of provision of this constitution relating to high court. So, as far the state judicial power is concerned, state judiciary is concerned, that power will not be disturbed. It is only the state executive power or state legislative power may be either taken over by the parliament or parliament itself may authorize the president to entrust the such responsibility to any authority or body which he think fit. So, here what the thing the president is doing under this provision, the president is generally or invariably entrusting the power of running the administrations of that particular state to the respective state government, or it may be assigned to the governor of some other state also. So, here as far the power of the president is concerned, here the president may also be authorized by the parliament to legislate with respect to any of the subject matter which pertains to the respective state government. In my previous lecture, I have already told you that the 7th schedule of the constitutions deal with the 3 list. So, if any of the subject which is mentioned in the state list, then with respect to such subject matter, it is the respective state government will have the power to make a law. But in case of emergency, with respect to all such subject matter, here the union parliament will have the power to make a law, or even the president may also have the legislative power in case if they have decided to impose the president rule or the proclamation under article 356 of the constitutions. So, after explaining you as to what are the conditions precedent for the imposition of president rule, is that either there has to be a receipt of report by the governor or suo motu, that is or otherwise, that is if the president has received the report from some independent sources, then that case they may be justified to impose the president rule. But the condition precedent is that the government of that state is not being carried out in accordance with the provisions of the constitutions, and as far the terms expression in accordance with provisions of the constitution concerns, it is a very wide expression and it has been used, it may be used for any situations pertaining to the mere law and order problems or complete breakdown of the administrative machinery of the state, the riots, natural calamities, or even the case like where the central government, where the state government is not following or abiding with the directions which may be issued by the central government time to time. But as far as the provisions like the article 174 clause 1 of the constitution is concerned, in the special reference case in year 2002, here the Supreme Court has clarified that if the state government is not, if the state legislature is not being conveyed as per the provisions of Article 174 clause 1 of the Constitution, then it cannot be considered as the valid justifications for impositions of precedent rule under Article 356 of the Constitution, and it is the responsibility of the election commissions to ensure the timely conduct of the elections to have the democratically elected government which will enjoy the majority in the state legislatures to run the government in that particular state. Now, I am coming to the durations as well as the procedural aspect of the impositions of precedent rule under Article 356 of the Constitution. If you see the provisions like the Article 356 clause 2 of the Constitution, then it provides that any such proclamations may be revoked or varied by the subsequent proclamations. It means if the President has issued proclamation under Article 356 of the Constitution, and if the President want to withdraw such proclamations, then that case they have to issue the subsequent proclamation for the purpose of withdrawing the proclamation which was issued or proclaimed earlier. But the Article 356 clause 3 is a very important safeguard which has been provided to ensure the possible check on the misuse of the power with respect to the imposition of precedent rule, and Article 356 clause 3 provide that every proclamation issued under this article except where it is a proclamations revoking a previous proclamations cease to operate at the expirations of the 2 months unless before the expirations of that period it has been approved by the resolutions of the both House of Parliament or by the Lok Sabha. So, as far the imposition of precedent rule is concerned, if any such proclamation is issued by the President, then it has to be laid before the both House of Parliament, and it required to be approved by the both House of Parliament within the period of 2 months. So, once if the Parliament has approved the issuance of proclamations by the President under Article 356 clause 1 of the Constitution, then the President will have the power to continue with the President for the period of 6 months from the date of proclamations of President rule under Article 356 clause 1 of the Constitution. So, here in this case it is not the date of the approval of the proclamation by the both House of Parliament that will be considered for the purpose of the continuation of President rule for the period of 6 months. Here this period of 6 months has to be counted from the date on which it was being approved, it has been issued by the President. So, as far this provision is concerned, here if any such proclamation is being issued, then it required to be approved by the both House of Parliament by the simple majority within a period of 2 months, and once it is approved, then the President will have the power to continue for the period of 6 months. If the President want to further continue the proclamations, then that case again they have to go to the Parliament and they have to seek the approval from the both House of Parliament for continuations of the proclamations for further period of 6 months. So, it is so after the expiry of 6 months, if the President want to continue with the President rule, then for after the seizures of the 6 months or after expiry of 6 months, every time they have to seek the approval of the both House of Parliament. Now, the questions will arise to what will be happened if the suppose at the time of issuance of the proclamations, if the Lok Sabha is being dissolved, or if the dissolutions of the Lok Sabha has taken place before it is being approved by the Lok Sabha. Then for such contingency, what is being prescribed is that if any such proclamation is being issued by the President, and if the Lok Sabha is dissolved at that point of time, or the dissolutions of Lok Sabha took place within this mandatory period of 2 months without approving the proclamations which was issued by the President, then such proclamations needs to be approved by the Rajya Sabha, and it is only after the approval of Rajya Sabha the President will have the power to continue with the proclamations for the period of 6 months. And if during this durations of 6 months, if Lok Sabha is not constituted or if Lok Sabha is not in existence, then for further continuations again it is required to be approved by Rajya Sabha. But if during this period, if the Lok Sabha has been constituted, then such proclamation will cease to operate with the expiry of 30 days from the date on which the newly constituted Lok Sabha meet. So, what the newly constituted Lok Sabha has to do in such case is they have to approve the proclamations for which the approval is already being accorded by the Raj Sabha or the constituted state. So, it is only after the approval by the both House of Parliament the President will have the mandate to continue with the proclamations for the period of 6 months. But as far the extensions of the durations for the 6 months is concerned, here the constitutions also provide limitations, and what the limitation which is being prescribed is that here the proclamations may be extended for the 6 months at a time, but it cannot be for more than 3 months, more than 3 years at a stretch. So, within this period of 3 years, here somehow the democracy in that particular state has to be restored. Here the electorate of that particular state has to be given chance to constitute a new state legislative assembly to run the administrations of that particular state. Here the Article 356 cannot be used as an instrument by the central government to run the government in that particular state as a proxy by using his agent, that is the governor. But if the situations are so alarming, or if situations are such that it is not possible for the election commissions to conduct the elections even after the expiry of the period 3 years, then naturally the question will arise that what the options which are available to the parliament or the president in such case. Here this kind of contingency is not being provided. So, if the president want to continue with the proclamations beyond the period 3 years, then that case the president is only having the options to seek the approval to go for the constitutional amendment, and it is only by the constitutional amendment specific provisions may be incorporated which may provide for the continuations of the president rule beyond the period of 3 years. And you can see that this practice is being adopted by the Parliament in case of the Punjab, when Punjab was suffering from the terrorism, and election commission has also expressed their inability to conduct the election in that particular state. Then that case here the constitution was being amended, and it provided for the continuations of the president rule beyond the period of 3 years, and the specific provisions pertaining to this is already being incorporated under the Article 356 clause 4 as well as the Article 356 clause 5 of the constitutions. So, as far the Article 356 clause 4 is concerned, it says that proclamation is approved by the parliament, it will remain in operation for the period of 6 months, but the parliament may extend the period of proclamations for 6 months at a time, but no such proclamations shall in any case remain in force for more than 3 years. So, after the expiry of the maximum period of 3 years, neither the parliament nor the president shall have the power to continue proclamations, and the constitutional machinery of the state has to be restored in that particular state. And if the president want to continue with the proclamations beyond the period of 3 years, then that case they have to go for the constitutional amendment. Now, I am coming to the provisions like the Article 356 clause 5 of the constitution, and it provides that the resolutions for the continuation of proclamations beyond 1 year shall not be passed by the either house of parliament unless first a proclamation of emergency under Article 352 is in operation at the time of the passing of such resolutions, and that the election commission certify that it is not possible to hold elections in that particular state legislature. So, only the two kind of contingency is being prescribed where the proclamations may be extended beyond 1 year at a time if the emergency in operations as provided under Article 356 clause 5 subclause A of the constitutions, or where the election commissions express their inability to conduct the elections within the specified period because of the any extraordinary situations, or even because of the non-completions of the electoral rules. So, it is for the election commissions, and election commission has to express has to give the they have to express their inability to conduct the elections within the specified period. So, only these contingency here the president rule may be extended for 1 year at a time, otherwise it has to be for period of 6 months, and it can be extended beyond period of 6 months after seeking approval from both house of parliament after the expiry of first 6 months. So, these are the procedural safeguard which has to be followed with respect to the impositions of precedent rule under Article 356 of the Constitution. So far I have explained you only that what are the provisions regarding the impositions of precedent rule under Article 356 of the Constitution, and what are the durations to which the precedent rule can be continued in the state, and what are the procedural safeguard which is being provided in the form of seeking the approval from both House of Parliament for continuations of the precedent rule which may be issued by the President under Article 356 of the Constitution. Now, I am coming to the second aspect of my lectures, and in this aspect I will try to emphasize on what are the grounds on the basis of which the precedent rule can be imposed by the state. The one ground which I have already explained to you under Article 355 of the Constitution, and 355 of the Constitution impose a duty on the Union to protect every state against the external aggressions and internal disturbance, and in performance of this duty the center can take over the state government under Article 356 of the Constitution. So, this is the one of the ground or justifications for impositions of precedent rule, by presuming that the government state cannot be carried on in accordance with the provisions of the Constitution. The other ground that is being specified is the Article 353 of the Constitution, and Article 353 of the Constitution provide that during the proclamation of emergency, if the state fail to run the government in accordance with the directions given by the central executives. So, if any such kind of direction is being issued by the central executives, and if the respective state government has refused to implement the directions which was issued by the President during the proclamation of emergency under Article 352 of the Constitution, then it could be one of the ground for impositions of precedent rule under Article 356 of the Constitution. The other ground that is being specified in Article 256 of the Constitution, and it provides that if the executive power of the state is not carried out in accordance with the directions issued by the union executives. So, and as far as the Article 256 is concerned, here the central executives or central government is empowered to give directions to the state government as to what needs to be done to ensure the compliance with the law made by the parliament and any existing law which may apply in that state, and executive power of the union shall extend to the giving such directions to the respective state government for this purpose. And apart from this, you also have the provisions like the Article 257 of the Constitution, where the union executives or union government is being empowered to issue the specific kind of directions to the respective state government to carry out the certain functions for the purpose of the protections of the property or any other agency or institutions or instrumentality in that particular state. And what is being prescribed by the Article 257 is that if the executive power of the state is not being carried out in accordance with the directions issued by the union executives, then it could also be one of the possible ground for the impositions of precedent rule under Article 356 of the Constitution. But the more substantive ground is being provided by Article 365 of the Constitution, and Article 365 of the Constitution prescribe that the effect of the failure to comply with or to give effect to the directions given by the union government. And what is prescribed by the Article 365 is that if the executive power of the state are carried out in such a manner that is not consistent with the directions of the center, then President may hold that situations has arisen in which the government of state cannot be carried on in accordance with the provisions of the Constitution, and in that case the President will be justified to impose the precedent rule under Article 356 of the Constitution. So, apart from these specific constitutional provisions where the state government is constantly disobeying the directions or the lawful directions which was issued by either by parliament or by the central executive or the central government. Apart from this, here some of the constitutional experts or the academicians have also given the suggestions with respect to as to what could be the other possible ground on which the precedent rule may be imposed by under Article 356 of the Constitution. And one of the grounds which was being suggested by the academician is that the failure of the state government to legislatively implement the directives which was being provided by the directive principle of state policy. So, if the state government openly refused to implement the obligation which is imposed on them by the directive principle of state policy, then it could also be one of the ground for presuming that the government state cannot be carried out in accordance with the provisions of the constitution. So, as far as the directive principle of state policy is concerned, if you see the approach of the constitution's maker, then for the constitution's maker there was not much difference between the fundamental right and directive principle of state policy, but it is only for the purpose of justiciability, it is purpose of enforceability. What is being prescribed is that the fundamental right are enforceable against the might of the state, but as far as the directive principle of state policy is concerned, it merely create a positive obligation of the state, and state is under obligations to carry out the necessary to frame the necessary policy for the purpose of implementing the various kind of the socio-economic obligations which is being imposed on the state by the directive principle of state policy. And if the state government fail to implement, then definitely in that case they will be directly responsible to the electorate at the time of next elections. But as far as the Article 356 is concerned, here some of the constitutional experts and the academicians have expressed the view that if the state fail to implement the provisions of directive principle of state policy, then it could be one of the grounds for impositions of precedent rule under Article 356 clause 1 of the constitution. Apart from this, here if some of the state is pursuing the anti-secular activity, then pursuing anti-secular activity itself is the sufficient justifications for impositions of or invoking the Article 356 of the constitutions and to impose the precedent rule, because here the secularism is being provided one of the basic feature of the constitutions by the Keswan Bharati case, and here we have adopted the concept of the Dharma Nirpekshta, where the state is being neutral in the matter of religions, and we are living in the multicultural, multi-plural society where the peoples of different caste, community, religions, ethnicity and cultures are living. So, if because the political considerations, if one of the democratically elected government is pursuing the anti-secular activity, if they are creating conditions which are not conducive for the welfares of the persons who belongs from the so-called minority community or person who belongs from the any other religions, then that case will presume that the state government is pursuing the anti-secular activity in violations of the provision of the constitutions, and it will presume that the government state is not being carried out in accordance with the provision of the constitutions, and it itself will provide the solid justifications for impositions of precedent rule under Article 356 of the constitution. Apart from this, we also had the other constitutional ground, because the expression the government state cannot be carried on in accordance with the provision of the constitution can be interpreted in any way. So, if suppose any democratically elected state government is pursuing or waging the war against the government of India, and if they are doing something which are directly detrimental to the maintenance of unity and integrity of the nations, then that case also the central government will be justified to invoke the Article 356 of the constitutions and impose the precedent rule in that particular state. So, these are some of the ground which may be considered the constitutional breakdown under which the president will be justified to impose the precedent rule under Article 356 of the constitutions. So, after discussing the constitutional breakdown, now I am coming to the other aspect, that what will be considered as the political disturbance. So, first I am taking the political disturbance, and what could be considered the political disturbance on the basis of which the president will be justified to impose the precedent rule. As far the term political disturbance is concerned, here it was subject to the judicial interpretations, and the judiciary has suggested some of the ground on the basis of which the central government will be justified to impose the precedent rule. And the first ground on which will be amount to the political disturbance or the instability in that particular state government is that if the majority government is reduced to minority because of the defections. because for the checking the unethical defections, we already have the specific provisions in form of the anti-defections law, which was being added by the Constitution 52nd Amendment Act, and here it has provided that only in the certain grounds here the elected members of the legislative party are allowed to defect from the original political party and form a new political party. So, if suppose after the elections, if the majority government is formed, and if that majority government is being reduced from majority to minority because of the defections of the some of the legislatures, and none of the political party are in positions to provide other viable government, because if that defected group is not willing to support to the opposition's political party. So, in case of the reductions of the majority government to minority government on account of the defections may be one of the grounds for presuming that it is a case of the political disturbance, and on the basis of which the president may be justified to impose the president rule under article 356 of the constitution. The other possibility that the suppose if one of the coalition's partners of the such coalition government withdraws support and majority government is reduced to minority government, then that case also the article 356 may be invoked by the president, and the governor may be asked to run the administration of that particular state until the alternative arrangement is being worked out. So, it is responsibility of the governor of that state to explore all the possibility of forming the more viable government. If the governor of the state has reached to the conclusion that none of the coalition's partners are willing to come on a single platforms to provide a viable and stable government, then that case they will not have any options than to request the president for impositions of president rule, because here the governor cannot allow the minority government to run the administrations of the state even as a caretaker government. So, if the because of the defections or because of withdrawal of the support by the coalition's partners, if the majority government is being reduced to minority government, then that case the governors may accordingly report to the president, and the president may be justified to impose the president rule under article 356 of the constitution. The other the eventuality which is being which will come under the purview of the term political disturbance is that if after elections, if none of the political party are in positions to provide a majority government. So, in that case here the governor will not have any options if they can explore all the possibility, and if there is not a case of the pre-poll alliance or it is not a case of the post-poll alliance, and none of the political party because of their inherent ideological contradictions are willing to come together on a common platform to provide a stable and viable government for the peoples of that particular state, then that case here the governor cannot allow the caretaker chief ministers to continue with the administration till the new government is constituted. So, in that case they will justify to impose the president rule, and after impositions of president rule they will keep exploring the possibility of forming the alternative government. But if no alternative government is in sight, then that case it is the constitutional obligations on the governor to accordingly request to the president or to request to election commission, because election commission has to request by the president to go for the fresh elections in that particular state. Here that they cannot keep delaying the conduct of the fresh elections merely because it is more suitable for the central government, or the central government is not thinking that this is not a time where they can directly go to the electorate and seek their mandate, because this kind of tactics cannot be adopted by the president by using the institutions of the governor to altogether dislodge or thwart the possibility of having the democratically elected government in that particular state. So, these are some of the political disturbance which was specified by the constitution's maker by the constitutional expert, on basis of which the president rule may be imposed by the president under article 356 of the constitution. So, after discussing the constitutional disturbance and the political disturbance, now I am coming to the physical disturbance as to what may come under the purview of the physical disturbance which may provide the justifications for the imposition of president rule. And one of the physical disturbance which has been construed as one of the ground for imposition of president rule, India is the failure of the state government to maintain law and order. So, if the state government is not is lacking will to maintain law and order, or they are incapable of maintaining law and order, then that case it will be responsibility governor to report accordingly to the president, and president will be justified to impose the president rule under article 356 of the constitution. Or suppose if that particular state government is going in such a situations where there is a lot of allegations of the corruptions, or there is a allegations of the maladministrations on the part of the state government, then that may also be one of the grounds for impositions of president rule. But as far as the corruption is concerned or maladministration is concerned, it has to be pervasive, and it has to be such a magnitude that it has completely shaken the very foundations of the constitutional spirits, and that case governor will be justified to presume that the government state cannot be carried on in accordance with the provisions of the constitution. So, accordingly he has to report to the president, and on the basis of the receipt of the report by the governor, the president will presume that the government of the state cannot be carried on in accordance with the provisions of the constitution. So, instead of directly, as far this provision is concerned, strict of directly going for the invoking the article 356, here the central government may even justify to appoint a specific inquiry commissions to investigate the charges of corruptions which may be level against either the chief ministers or the ministers or some other officers of that particular state, or those who are the members of the state executive. So, and the constitutions of inquiry committee by the central government to investigate the charges of the maladministrations or the charges of corruption is already being upheld by the judiciary by saying that it is not something which is going to destroy the very existence of the federal scheme of the constitution, but it is something which is intended to ensure or to strengthen the very fabrics of the Indian constitution. Apart from this, under the physical disturbance, here some other extraordinary situations like the violence in the form of riotings or the natural calamities like in the form of the flood, earthquake of the severe natures or the tsunami may be construed as one of the grounds on which the president rule may be imposed for the time beings. And if you see the provision like the article when the constitution was being amended by the constitution 42nd amendment act, then that case here the article 257 clause 1 was being inserted, and what is being prescribed that if there is any law and order problem in a particular state, then that case here the central government may be justified to send the armed forces or the CRPF in that particular state without the consent or the concurrence of that particular state government. And this provision was being badly opposed by all the state government, that before sending the central forces or the armed forces in the state government, here the view of the state government has to be taken, or there has to be specific request by the state government before interfering with the administrations of that state government. So, because the severe criticism or objections to these provisions, here this provision was being amended by the constitution's 44th amendment act, and article 257 clause 1 which was being added is now being repealed. So, these are the three specific grounds on the basis of which the president rule may be imposed or could be imposed in the particular state. So, apart from this, here this issue has also agitated the mind of the various constitutional expert, and as well the different commissions and the committees being constituted by the successive central government to examine the whole gamut of the center state relations. And with respect to this, I am just first pointing out the recommendation which was being given by the Administrative Reform Commissions of 1968, and this commission has recommended that the report of the governor regarding the president rule has to be objective, and also the governor should exercise his own judgment in this regard. So, as far as the power of the governor regarding the report is concerned, here under the constitution the governor of the state is required to send fortnightly report to the president or to the Union Home Ministry regarding the prevailing law and order situations of the state, and also what are the important decisions which was being taken by the respective that particular state government apart from the general observation. So, if the governor is giving any kind of the adverse reporting regarding the prevailing law and order situation in the state, then that case what was being recommended by the Administrative Reform Commission 1968 is that such report has to be objective and it should be based on his own judgment, and the judgment which the governor is required to exercise, it has to be sound judgment. So, but as far as this practice of the sending report is concerned, in a routine or in unusual circumstances warranting the presidential intervention, the governor is expected to exercise his own judgment. So, the crux of the recommendations of this commission was that here whatever the report has to be given, here they have to be analyze the existing situation in objective manners, and they have to report to the president accordingly. So, this provision has acted as an important restraint in the exercise of presidential power under Article 356 of the Constitution, but these recommendations were not implemented by the central government due to the lack of the bill power. Then after the Administrative Reform Commissions, the committee of the governor was being constituted by the president. The then president was B.V. Giri in 1971, and this committee is known as the Bhagwan Sahai committee report. The Bhagwan Sahai, he was the then governor of the state of Jammu and Kashmir, and along with the Bhagwan Sahai, here the Gopal Reddy as well as the Aliyavar Jung and S.S. Dhawan was the members of this committee. Here this committee has given its recommendations in year 1971, and this committee has given the far-reaching reporting regarding as to what are the circumstances under which the president rule may be imposed by the state and what needs to be done for the purpose of maintaining a harmony between the central state relations. So, as far as this report is concerned, here what is being suggested by the Bhagwan Sahai committee report in 1971 is that it is the responsibility of the governor to see that the administration of the state does not break down due to the political instability, and he must send a regular report about the political situation of the state. And the committee has also suggested that governor should also report to the president about any serious internal disturbance or external aggression in the state concerned, and about the actions to be taken under Article 356 of the Constitution. So, here this committee has also suggested that the government which was constituted in that particular state, it should not be lightly disturbed or superseded by impositions of president rule under Article 356 of the Constitution, but if there is a possibility of the existence of any external danger in the form of the external aggressions, or there is a possibility of internal disturbance because of the complete breakdown of the law and order situation in the state, or because of the inability or the lack of bill on the power of the state government, then that case here the governor may be justified to request the president regarding the invocations of the president rule under Article 356 of the Constitution. But as far as the guiding principles for exercise of power by the governor is concerned, here this Bhagwan Sahai committee has also emphasized that it is the best judgment of the governor has to be considered as yardstick for the purpose of impositions of president rule under Article 356. So, after the discussing this Bhagwan Sahai committee, now I am coming to the other important committee report which was being submitted by the Raj Manar committee, and this committee was being constituted by the DMK government in Tamil Nadu in year 1969 to examine the center state relations, and this committee was given the mandate to inquire about the center state relations. So, here this committee also known as the Center State Relations Inquiry Committee, and this committee was being headed by the former Chief Justice of the Madras High Court, that is the P.B. Rajmanar. And if you see the some of the suggestions which was been given by the Manar committee, some of the recommendations was very drastic in nature, and the very first recommendations of the Rajmanar committee was that they recommended for the repeal or deletions of the Article 356 and 357 of the Constitution, and what he suggested is that necessary provisions for the safeguard against the arbitrary actions of the ruling party at the center under Article 356 should be incorporated in the constitutions. So what was the view of this Rajmanar committee was that the Article 356 and 357 may entirely be repealed. But if you see the other recommendation, then this committee has emphasized that the governor of the state should not consider himself as an agent of the center, but play his role as a constitutional head of the state. So by this committee here, this committee has somehow tried to enlighten the governor as to what are the responsibility which has been entrusted upon him by the sacred law of this country in the form of the constitutions, and he should not merely act as a puppet or the agent of the central government, and he should exercise the best judgment, and he should act as a protector and the guardian of the constitution instead of acting on the advice of the respective central government. Apart from this, here the other recommendation of this committee was that the governor, before recommending the precedent rule, should explore all the possible avenue open to him to secure a ministry which could command the confidence of the legislature. So if there is case of the political disturbance, and if none of the political party and positions to provide the stable and viable government, and no pre-poll or post-poll alliance is coming forward to form the government, then that case, before recommending the president for imposition precedent rule, here this committee suggested that the governor should explore all the possibility for the formations of the viable government state, and if they fail, then only in that case he will be justified to recommend for the imposition of precedent rule. And the other contingency which was being upheld by the Rajmanar committee was that here the governor of the state would be justified to impose a precedent rule if it is a case of the complete breakdown of the law and order situation in the state. But what are the other recommendations was that the only forum which could decide about the questions whether the ministry could continue in office of the legislature, it has to be decided on the floor of the house. So these were some of the recommendations which was given by the Rajmanar committee regarding the impositions of precedent rule. But as far as the Article 365 of the Constitution is concerned, here this committee has suggested that any contraventions or the failure to implement the directions issued by the union government to the state under Article 365 is concerned, under no circumstances it should be construed or made as a specific ground for impositions of precedent rule under Article 365 of the Constitution. So obviously, as far as the Rajmanar committee is concerned, it is a very important recommendation which was been given for the purpose of maintaining or restoring the autonomy of the state, and it is also suggested that some of the checks upon the possible misuse of the provisions by the president in the form of impositions of precedent rule. But here all the recommendation was not being accepted by the central government, and it was being rejected by the union government, and that is why we still continuing. So after discussing this, I think the time will not permit us to continue beyond this point, but in my next lectures I will take up the detailed recommendation of the Sarkaria Commission recommendations, as well as the judicial interpretations to the provisions of Article 356, as well as how the Article 356 was in action since independence for more than 112 times.
With this note, thank you sir, thank you so very much for giving us a very productive session. Thank you.